Okay, well, we could probably get started. Welcome everyone to Wednesday webinars with the Utah Center for Legal Inclusion. This month, as many of you may know, we are talking about law and politics. And so today we have Professor Dane Thorley with us. And just as a preview to the next couple weeks, next week we will have Marina Lowe, who is Legislative Counsel for the ACLU of Utah. And she'll be talking about her work in using her legal training to advocate for legislative change and policy. And then the next week, we will have a panel that will include Representative Stephanie Pitcher, who is an attorney, but also one of our state legislators, and then two attorneys that work for the State Office of Legislative Counsel, who are the attorneys that actually write the bills that different legislators want to propose. And so they'll be talking about the actual process of how legislation is written and how attorneys are involved in that. So hopefully that will be an interesting educational one to listen to and learn more about that process, because I would actually like to know a little bit more about that myself. So, but today I'm really excited to have Professor Thorley with us, Dr. Thorley. Dane and I worked together at BYU when I was a professor there. His office was right across the hall from mine, and we teach the same topic. So I'm really excited to have him here today to talk about his research and his career. And so I will call him Dane, and you guys, I guess we don't actually have audio. But we can, if you have questions, please put them in the Q&A, I should say that, and we'll have time at the end. But if you have them throughout, definitely feel free to put them in there. And we'll start out with, I mean, I introduced him as my friend, but Dane will give us an intro as to how he came to be a lawyer and a law professor and what brought him to the law.
Sure. Thanks, Melinda. So what I think you'll find as you get to know more lawyers that we generally don't have great answers for why we decided to become a lawyer. And I don't know why I always wanted to go to law school. It was something that was kind of in my mind even when I was in junior high. I didn't even know what that really meant to go to law school, but I liked the TV shows that included lawyers. People would joke that I was good at arguing, so I would make a good lawyer. And so there was always an interest in the back of my mind in going to law school and being a lawyer, even though I didn't have any family members who were lawyers. I didn't really know what that meant. The lawyers I did sort of know, or at least the kids of lawyers I knew, tended to have nice houses and nice cars. So that seemed appealing to me. But I really didn't know what it was to be a lawyer. And so I went into college feeling like I had to pick some career. I don't think that's true, but that's how I felt. And I imagine a lot of you in college are feeling that way too. And so I picked political science as my major because people told me that's the major you take if you want to be a lawyer. Also not true, but that's what I was told. And was in my sophomore year and started to get to the point where I actually did have to start figuring out what I wanted. And was told that if I wanted to go to a good law school, I had to get good grades and do well on the entrance exam, but also that I should get good letters of recommendations from professors. So I started working with professors in the political science department and ended up working with one who specialized in running field experiments. And I'll explain what those are in a little bit when we get to some of my research. But started doing some of those with him and really liked it. Liked the research process, liked running these field experiments, was interested in the sorts of things that we could do with the data that was coming out of the field experiments. So I started to reconsider whether I wanted to go to law school or not, and thought, well, maybe I can do a PhD and teach and research, do research. So I sort of, for about a year, went down that path where I'm, okay, I'm going to prep for a PhD programs as opposed to law school. But that ended up, one of the co-authors with my supervisor was at the law school at the time, Shima Baradaran-Bauman, you might know her, Melinda, and realized, hey, she's doing this sort of cool thing with field experiments and research. She's researching interesting areas that intersect with questions that legal scholars are interested in. Maybe I can do what she did. And after starting some discussions with her and with some other people, realized that that was a really viable path for someone who's interested in law, but also interested in doing research related to policy and politics. And so I decided I'm going to try to do a JD PhD, so get a law degree and also get a PhD in political science to set myself up for a career as a law teacher, as a law professor. And long story short, and the story is long because I went to lots of school. I went to school, other than a 2-year break for a mission for my church. I was in school from age 5 to 30. So no breaks, just school. And I loved it. And it's good I love it because I'm back. I'm on the other side, but I'm back in school again. Took a pause for a bit to do some legal stuff as a lawyer and clerking. And so my research, I do these field experiments and randomized experiments related to law. I'm sort of a roving empiricist. And what I mean by that is, because I have a skill set that most law professors don't have, which is using data and statistics to study law and policy, I didn't have to pick a particular issue I wanted to study. I can study multiple things. So we'll be talking about some research I'm doing right now relating to judicial elections and recusal. But I also do work in criminal justice and criminal justice reform, and then do some very boring work that's just in methodology. So how to properly do the sorts of things that I'm doing. And I don't recommend, if you're interested in what I'm talking about, I don't recommend you read those papers. They're very boring. I think they're important, but they're very boring, as opposed to what we're talking about today, which I think is really interesting. So maybe before we move into research, I don't know if anybody has any questions just about sort of my path to where I am now. I'm happy to talk about that. Or if we want to wait until after we talk about this research project that I'm working on, I can just answer a grab bag of questions. And like Melinda said, feel free to interrupt me. We don't have to wait until the very end to answer questions. And so send Melinda any
I will
messages
say,
you have.
Dane, none of the participants have the ability to actually speak because
Right.
we're in the webinar format, but please put questions in the Q&A. One of my interns did email me with a question actually on this very note that you said. He did notice from your bio all your education, right? And so he said he wanted to know, like, at what point did you feel like you had decided what your research was going to be about, or like what your career was going to look like?
That's a good, well, those are two different questions. I think there was this sort of epiphany that I had in my junior year where I realized I could do this sort of research in an area of law, which I had always been interested in. And I think at that point, I was confident enough that that was something that I would enjoy doing. And it was something that was needed. So there would be a demand for the sort of work that I would do, that I could really confidently go into post-undergrad education, focusing on being a law professor as a goal. It's hard to get a job as a law professor. It's very competitive. And so I wasn't sure whether it would work, but I was certain that that's what I wanted to do, was to study law. In terms of when did I decide what I wanted to study? I mean, I think part of the answer to that is I still am figuring out what I want to study. I'm someone who I think fortunately has the ability and the skill set where if an interesting question comes up and it's not really in my wheelhouse, I partner up with someone who's a substantive expert in the area, and then I lend my methodological skills to studying that. So having that skill set has really allowed me to be flexible in the sorts of things I study. But I actually went into this law school and PhD program. If somebody asked me what I wanted to study, my answer was North Korea. So I had spent some time in South Korea. Over one summer, I was working with North Korean refugees. So these are individuals who fled North Korea, and was doing some research with them. And the plan was that I would be the expert on North Korean law and economics, so that if it opened up, I could be someone that the international community could tap to help them sort of rehabilitate, not even, you can't rehabilitate a democracy that didn't exist, but build a democracy, write a constitution, write economic policies that would allow them to sort of transition into a functioning country in relation to the rest of the world. And that, for various reasons, became sort of not feasible as a research path, although I'm still interested in it. And I ended up focusing on judicial politics and getting into criminal justice and criminal justice reform over the last 5 or 6 years. And so it was a slow process for what exactly I wanted to do within the profession of legal teaching, but I was lucky enough to have, I mean, it seemed to have worked out for me, but whether or not I should have been as confident as I was lucky enough to find the confidence to say, this is what I want to do, and be willing to, and be able to convince my family to put up with, not having a job for 8 years. As a PhD student, I had a small stipend, but as a law student, I had to pay tuition. And, that's, I had my first real salary job at 31. And so, it was that was a long process. And it was very nice to have the confidence of knowing that's what I wanted to do. Because I think there probably would have been times where I would have said, you know what, this isn't worth it. I'll just be I'll be a lawyer and work for a big firm. If I wasn't really had the conviction of knowing that this is what I wanted to do. And a lot of that came from being able to do it in some part as a research assistant early on. So those of you in college who might be interested in pursuing a career as a law professor or a professor in general, I mean, you've got to work with professors to see what it's all about, and that will help you. It was for free in a lot of cases, and I was getting paid in the experience, not my what would have been a minimum wage hourly job. So good question.
But I think that's good advice to test the waters as much as possible, right?
Yeah.
So,
yeah.
I'm really excited though to hear about what you're doing right now. So why don't you tell us about your current project?
Yeah, if you want to, and I don't know if I have screen sharing. You may. Let's see. Okay, so I don't have it right now. If you want to give it to me, I can.
I should do that beforehand. I'm sorry.
Yeah, no problem. I'm going to set up a system so that you can kind of see me while I'm presenting slides. So I'm probably going to go dark, my camera, but you should still be able to see me.
You are now my co-host.
Okay. Okay, that's not going to work. You don't need to see me. I'll be back in 10 or 15 minutes, but we can share the screen and get this slide going. Okay, let me know if you can see the slide. It has got a title. It's got my mouse poking around a little bit. Okay, good.
Yep,
so
good.
I think there's a lot to talk about here, and not everything that comes up on the slides I'm going to talk about, mostly in the interest of time. But if any of you see anything that I don't touch on that you'd like to talk about more, let me know. So this project touches on a few interesting topics that I think we can have a discussion about after I finish the presentation, or again, if you have any questions in the middle, I'm happy to stop. But it's a project that deals with judicial elections and the fact that judges, when they run for office, generally tend to raise money, just like other politicians do. So many of you may not be aware that judges are elected. For some of you, that may be sort of not surprising at all. Well, judges are part of the government and government's elected, so of course judges will be elected. But for many of you, you may not realize judges are elected because it's just not something that's on our radar when we're thinking of elections as often. And particularly, the United States is pretty unique in that we elect our judges through popular elections. Most countries appoint their judges and there's various ways that that can happen, but they don't let the people choose who the judges are going to be. And we could spend a lot of time talking about the advantages or disadvantages of elections versus appointments. But one of the interesting things that come out of the fact that judges are elected and run for elections is that they need to raise money to campaign. And most of their money comes from attorneys or law firms that argue cases in front of those judges. Now, there's all sorts of concerns related to money in politics, but they become particularly acute when we're talking about judges, because judges, unlike a congressperson or a governor, are supposed to be neutral. So they're by definition supposed to be neutral, whereas the governor is elected on a platform, and that governor has, I'm a Democrat, or I'm a Republican, or I'm progressive, or I'm conservative, right from the get-go. Judges are not supposed to be like that. They're supposed to look at the law, take the facts of the case that are presented to them, and then sort of be a neutral machine where they suck in the facts and spit out a ruling that is not impacted by outside factors, specifically not impacted by the identity of the parties or the attorneys who are participating in that case. But with elected judges who are raising money, and that most of that money comes from attorneys, we start to become really concerned that maybe that money is affecting the way that judges do their jobs. And in particular, I think a big question is, does donating to judges, either as an attorney or as a party, increase the likelihood that you're going to win the case? Because if it does, then judges aren't being neutral. They're playing favorites, and that's not the way the legal system is supposed to work. So this project sort of takes that basic situation and asks, what policies do we have in place, given that judges are elected and given that judges do raise money? What policies do we have in place to try to prevent that sort of bias to creep into the system? And the most prominent approach to dealing with judicial bias, not just in the context of campaign donations, but in general, is the process of recusal. And recusals, and if you've been watching the hearings for Judge Amy Coney Barrett, the word recusal has come up a lot, and it's going to be a hot topic over the next few months. The concern there is, if Judge Coney Barrett is appointed during an election by a president who's running in that election, is she going to be biased in favor of that president or his policies when she's sitting in the Supreme Court and having to evaluate whether or not something's constitutional or legal? And we could talk about my opinions on her in particular and that sort of scenario, but I think it highlights the basic idea behind recusal, which is, if a judge is biased in favor of a party, or, as we'll see in a minute, if that judge is perceived to be biased in favor of that party, then in many cases that judge is required to remove herself from that case, either to be replaced with another judge, or in the case of a court like the Supreme Court, just to be off of the voting panel. And my question with this study was, are judges recusing from cases in which one of the attorneys has donated? And if they're not, what can we do outside of the current policy structure to sort of incentivize them to remove themselves from the case? And I'm going to run through a few more preliminaries, and then we'll get into what exactly I did to study this. So just so you're familiar again with recusal, it's the idea that the judge is removing herself from a case. Policy-wise, recusal provisions generally come in three forms. So there are laws or regulations that require the judges to recuse themselves. So it's mandatory recusal in certain circumstances. For example, if I'm a judge and my daughter is a litigant or an attorney, in basically every state and in the federal system, I'm required to remove myself from the case. There's no discretion involved. It's called per se recusal. It's just automatic. I need to remove myself from the case. But there are all sorts of circumstances that can come up that aren't specified specifically in laws. And some states take the approach that judges only need to recuse themselves when they're actually biased, or there's actual partiality towards one of the parties. And other states and the federal system takes the approach that you need to recuse yourself even when there's an appearance of that bias. And so one example of this is it was a Wisconsin statute that requires recusal when a reasonable, well-informed person would reasonably question the judge's ability to be impartial. If you're reading that and thinking, oh, that's not really clear on when exactly a judge should recuse herself, you're sort of right on the money, because this is a really vague statute and gives the judges a lot of discretion, which means that judges don't recuse themselves very often. And some previous studies have shown that judges really don't recuse themselves. And part of what I did in this project was try to codify all the reasons that a judge might have a difficult time removing yourself from a case, even if bias exists, or even if a perception of bias exists. And the first factor here is that judges have a lot of discretion in this area. So one of the main purposes of judges is that we want someone who's not involved in the case to make a decision, so that they're not influenced by the emotions involved or the finances involved in the case. But with judicial recusal, the judge is making a decision about herself, and is acting as the judge sort of in her own case. And so the way that recusal decisions are structured, the fact that the judges make their own decisions, is naturally going to result in judges being less willing to remove themselves from cases. There's also a lot of psychology on the fact that individuals tend to overestimate the amount of bias that other individuals have and underestimate the amount of bias that they have. So we're prone to accuse others of having bias, but unable to identify that same level of bias in ourselves. So even a well-intentioned judge is generally going to be less able to identify bias or perceived bias within themselves. There's also cost to recusal. So anytime a judge removes herself from a case that she spent some time on, the new judge is going to have to spend time sort of rehashing the case, going back through materials, relearning what the original judge had already learned. So there's actually an economic and administrative cost. There's also with judges a reputational cost. Judges pride themselves on being neutral and being able to distance themselves from the particulars of the case and just give the legal interpretation. And so by admitting that you're biased or there's a perception of bias, you may be admitting that you're not as good at your job as you would like. And then in the context of elections, if people are donating to your campaign and you are recusing yourself from any case that involves them, they may be less likely to donate in the future. And that's going to be tough for judges. So again, going back to policy. So what is our policy approach to dealing with this? Individuals and states that have recognized that this is a problem, that judges might be less likely to remove themselves from cases, have taken various approaches to dealing with that. The most common approach is to increase transparency and make sure that the decision-making process isn't just the judges. So if the judge is biased, or if the judge has a relationship or is potentially biased in favor of one of the parties, as long as we let the non-connected party or the non-connected attorney know about it, they can push for recusal, and they'll be incentivized to identify bias and push for recusal. This is a quote from a Supreme Court Justice Brandeis, a really old one that's pretty famous, although you tend to hear it. It's never almost a quote, it's some variation of this. But sunlight, in other words, transparency or information, is said to be the best of disinfectants, by which he means as long as people are informed, bias or corruption is not going to be able to work. If information's out there, the people will push for these sorts of problems to disappear. And so the takeaway from that in this context is, okay, as long as the judge discloses the potential bias to all of the parties involved, someone's going to be properly incentivized to try to figure out whether this is actually a problem. So yeah, judges might not be that good at recusing themselves from cases, but as long as we require them to be transparent, then we don't have to worry as much as their inability to judge themselves in this regard. And so the sort of going into this project, my problem with that is that there's all sorts of reasons why attorneys might not be willing to push for recusal, even if they feel like recusal would be necessary. This is just a quote that I heard from a few Texans I interviewed in the course of the project. It says, if you point the barrel of a recusal motion, or if you ask a judge to recuse, particularly a Texas judge, make sure it's loaded with a silver bullet. In other words, if you're going to question a judge's impartiality and you're going to ask them to remove themselves from the case, you better be darn sure that they're going to remove themselves from the case, because if they don't, then you're going to have an angry judge who may be even more biased than they were originally. And I'm not going to spend a lot of time on these, but these are factors that might disincentivize an attorney from asking a judge to recuse. One thing to note particularly in the state court context, even if you successfully get a judge to remove themselves from a case, you're going to be back in front of that judge as an attorney in a few weeks with another case. And so to the extent that you're worried about judges sort of holding a grudge against you for questioning their impartiality, even in the best case scenario where you get a judge to recuse, that judge you may be disadvantaged and your clients may be disadvantaged in the future with another case. So little context for judicial elections. We talked about this at the beginning, but there is some empirical research on whether or not donations make a difference. It's a really sticky causal question because maybe people are just donating to judges that they already know are going to be favorable to them. So judges aren't being proactively favorable towards certain parties. They're just the type of judges that would rule in favor of those parties anyway. And so those parties know that, or those attorneys know that, and they're donating to them. So there's mixed research on whether donations and money to judges actually impacts the outcome of cases. Although I would say that the combination of all the studies suggests that there is an effect here. But even if there isn't an effect, most people believe that there's an effect. And so we may want to require or find a way to get judges to recuse, even if there's no bias, just because people are concerned about that bias. And the vast majority of Americans believe, when they've been polled, that contributions affect case outcomes. Business leaders believe that, and even judges themselves believe that. So the majority of judges in the United States believe that, or a near majority believe that donations influence their decisions, and more than a majority of them believe that recusal should be required when someone's donated to the judge's campaign. And we're going to come back to this because this kind of gets to the psychological effect that I discussed earlier, where judges are pretty good at identifying other judges' bias, but when it comes to their actual behavior, we don't see near this number of judges recusing themselves from cases. Okay, so just a quick run over of the experiment. There's going to be a lot of slides here that we're not going to spend time on because it kind of gets into the boring and nitty-gritty details of the design of the experiment. What I did is I identified active cases in state trial courts in Wisconsin and Texas, in which one of the attorneys had donated to the judge's political campaign. So political donations are publicly available. Sometimes it's a little tricky to get it, but you can see who donated to who. So I had information on who donated to who. I was able to get information on which of those people were attorneys. And then every week, I had a computer program go through all of the new cases in Wisconsin and Harris County, Texas, to identify cases that featured attorneys who had donated to those judges. And so every week I got a few cases in which an attorney had donated to a judge. And what I did here in this experiment, the experiment part of this was every week I would effectively flip a coin for each case. If it was heads, I wouldn't do anything. And if it was tails, I would have an NGO that I was working with send the judge a letter that I may have. This is sort of the contents of the letter. It basically said, "Hey, judge, we noticed that you were assigned this case, and we also noticed that one of the attorneys in that case had donated some amount of money to your previous campaign. You're not required to recuse here, but we think that you should." Because people are concerned about this sort of thing. And so the judges, half of the judges that I studied got this letter that said, "Hey, we know about this case, and we know about this guy that gave you some money, and we think you should recuse." And so what we were looking at in this study was, can a third party, so given all the policies that are already in place, how often do judges recuse, and can third parties increase the rate of recusal and increase the rate of disclosure? Because we also wanted to test this idea that disclosure might have an effect on judge or attorney behavior. And well, these are the outcomes. So this first column on the left, called the non-experimental column, were just cases that weren't included in this randomized experiment. And so it's sort of a base level look at how often judges recuse themselves from cases in which an attorney has donated to their campaign. And as you see, not a lot of them do. 6% of the judges recuse themselves from cases. And looking more into the details, most of these recusals weren't done for the donation. They were done for other reasons. But because judges weren't always clear in the reasons why they recused or not, we decided to include all recusals in our outcomes here. So 6% of cases that featured a donor attorney, and this is just Wisconsin data, had a recusal. All the others didn't. So then we looked at what we called our control cases. These were the cases that got a heads when I flipped the coin and didn't get a letter. And we see that basically the same proportion of judges, in this case, 2 out of 32 judges recused themselves from cases. So this is a good indication that the cases we looked at in the experiment were reflective of sort of the wider population of cases. And then the big question is, does this letter, sort of an odd letter, frankly, a letter that judges probably aren't used to getting, does that induce judges to recuse at a higher rate? And the answer is yes, but no. So 8.8% is technically higher than 6.4%, but it's something that we call it statistically indeterminate. So it is not clear to us that this is anything other than some random noise. So it's slightly higher, but as an empiricist, I can't tell you that this is actually the result of the letter. This might just be the result of some random noise. And so the takeaway here is judges don't recuse from these cases, and they don't recuse even when you ask them to. So even getting a letter doesn't change the rate of recusal. The next question is, do judges disclose? Because again, sort of the main approach to dealing with a lack of recusal in policy and in the legal scholarship is, well, let's just make sure that judges disclose. So the first question is, do judges disclose normally? And the answer is no, they don't, not at all. In none of these cases, so in none of the cases where, and we didn't spend any time on this, but the laws in Wisconsin seem to indicate that your judges are required to disclose in any case that might even be perceived as one that has bias in it. So we were expecting a lot higher rates of disclosure, but judges don't, or at least if they do, they're not doing it on the court record. Maybe they're mentioning it after the recording stops. But none of the judges in the non-experimental group set disclosed. None of the judges in the control group disclosed. But it turns out that, whoops, wrong direction. Turns out that 1/3 of the judges in the treatment group disclosed. So when we send judges letters, they're no more likely to recuse themselves from cases, but they are more likely to disclose the fact that one of the attorneys donated to the other parties or attorneys involved in the case. And this was really good from a research perspective, because then this allows us to sort of test the effect of disclosure. Because here, the difference between the control group and the treatment group is random assignment. And so if only the treatment group is disclosing, then we can also treat disclosure as sort of a randomized assignment. And so we can see, are the attorneys in the treatment group any more likely? We've already seen that the judges aren't any more likely to recuse. So disclosing doesn't increase recusal rates, but does disclosure increase the probability that an attorney asks the judge to recuse? That's the suggestion with disclosures, that attorneys are they're gonna be properly motivated to ask, and they will. And it turns out that they don't. So attorneys never ask judges to recuse, even when they know about the donation. So we know that the in the treatment group, 1/3 of the attorneys know about this donation. We know because it was disclosed on the court record, but in none of those cases did the attorneys ask. And so the implications of this, we're still sort of working on exactly what we think this implicates. But the easy takeaways are, judges don't recuse. They don't recuse and they don't disclose. And it seems like disclosure, at least in this context, in the context of judicial campaign donations, don't induce the sort of behavior that we want them to. A few things to keep in mind, sort of limitations of the study. It's possible that the judges don't know about the donations. Now, we know that they know about the donations in the treatment group because we know they all received a letter that told them about the donations. So we know that at least in the treatment group that they know about the donations. The judges may sincerely not believe that donations are an issue. And I think that's at least true for some of the judges. Some of the judges just don't believe it's an issue. And some of the judges probably should recognize that it's an issue for them. But like we talked about, as humans, we're just not as good as at identifying our own biases. And so judges are just less likely to identify that. But maybe the attorneys don't care either. And I did a lot of interviews with attorneys in Wisconsin and Texas to try to gauge whether they felt that this was a problem. And there were some that sincerely didn't think it was, but there were a lot that did. And that indicates that these attorneys thought it was a problem, knew in some of these cases that judges had received campaign donations from the other side, and still didn't feel like it was worth it to push for recusal for a lot of the reasons that we discussed above. It's just too costly for them and their clients. They're just going to have to deal with the bias that they have, because they may induce greater bias if they start asking the judges to recuse. There's some empirical limitations that we can go over later if you want, but I think maybe what we can start the discussion on is, okay, so judges don't recuse. Disclosure doesn't seem to induce recusals, so what can we do? And one alternative is, well, let's just we talked about this category of recusal rules that require judges to recuse and takes away their ability to make decisions, mandatory recusals, per se recusals. Why don't we just extend those rules to cases where one of the parties or one of the attorneys had donated to the judge's political campaign? One thing is that would be unpopular. So judges wouldn't like that, and attorneys wouldn't like that, particularly attorneys who are donating to judges. But another interesting thing that comes up here, and this is true in any state that has donations to judges, but there's only a few states that have mandatory recusal, and Utah is actually one of them. So Utah is one of the, I think, currently 4 states that requires recusal if you donate above a certain amount. And in Utah, that amount's really low. It's $50. So if you appear in front of a judge as an attorney or a party and you've donated $50 or more to that judge has to recuse. Now in Utah, it's sort of different. Utah has retention elections, and so there's just not as much money involved in Utah judicial politics, and so this doesn't come up as often. But imagine California has their cap is at $1,200, just above $1,200. But imagine that California's cap, and California doesn't have retention elections. They have, well, they do sometimes, but they have general elections for judges. We sort of run into the opposite problem, where if we're requiring judges to recuse for any donation above $50, and I don't like a judge as an attorney, it only costs me $50 to prevent my cases from ever appearing in front of that judge. And so I can, for a pretty low fee, sort of pay my way out of appearing in front of certain judges, which gets us into sort of the same problem that we came in the beginning, where attorneys are able to use money to influence the outcome of cases by going to judges that they think will be more favorable to them. We can have other judges make recusal decisions for judges, but it turns out that those other judges are also elected, so they may not be incentivized to require recusal for other judges. And this is a mouthful, and I don't think we need to spend too much time on this, but my suggestion is that we require disclosure by the court. So the court can get data, just like I got data on these sorts of relationships. So the court discloses to the parties right at the beginning of the case that there's a donation here. And then the attorneys have basically a skip card that they can use. The attorneys don't even have to ask the judges. They can just say, yeah, I want this assigned to another judge, and the judge doesn't have any discretion. And in fact, if they do it early enough, the judge doesn't even know that they were assigned to the case in the first place. Some other sort of bigger, larger institutional changes is maybe we can get rid of elections for judges. There's a lot of discussion on that, but I don't spend any time on that because I don't see judicial elections going anywhere anytime soon. It's a pretty popular system in the states that it exists. We can also change judicial campaigns finance laws. So think of ways to anonymize donations. There are some constitutional issues that will come up if we start playing around with whether or not people can tell judges that they donated, because donations are considered free speech and protected under the First Amendment. Currently, according to the Supreme Court's interpretation of the First Amendment. So that would run into problems, but that's another possibility. So I think there's other things to talk about here. we can talk about this in the context of the Supreme Court and Amy Coney Barrett. We can talk about, what's it like? Are judicial elections any different than other elections? We can talk about whether what I did was very nice, sort of intervening in these cases. Was that ethical? Should I be doing this sort of research? We can talk about whatever you want. So if you have questions, why don't you, this is a good time to send them to Melinda and we can start having a discussion on this sort of stuff.
Thanks, Dane. While people are maybe typing their questions, I have one of my own. First of all, I had this thought, the anonymous donations, but you're right, it raises a lot of interesting concerns. Mine is more like curiosity based, but did you get any interesting responses to your letters or
from the judges?
Yeah.
Well, no, not really. The reason, well, yes. Okay, so the reason why I didn't present the Harris County data is because halfway through the experiment, we got a letter from one of the attorneys at the court saying, please stop sending us letters. And not only did we not want to annoy people, and so we stopped sending letters, but there's also some, with experimental methodology, there's some problems if all of the judges know that that some people are receiving letters and some people aren't receiving letters. There's some, it's called spillover problems. And we can't trust the results of the experiment as much if other people know about it. So that was an interesting letter. Otherwise, we had a few judges reach out to the NGO, basically saying, well, I don't really know what's going on here, because the NGO was based in New York. Okay. And so they're like, why are you interested in this case? And so we had some questions about that. We also had a couple, there were only a handful, 3 or 4 letters or emails or phone calls that were made. We had some judges basically say, just so you know, this is not a problem. I'm not biased. I'm not sure why you would think that, but nothing to see here were sorts of letters that we received. I suspect that once we publish the results of this study, we may see more interesting responses because the judges didn't know they were being studied, right? They thought, and they were receiving letters from a real NGO, but it was all sort of a pretense for the study. And judges don't like to be studied. I mean, people don't like to be studied in general, but judges in particular, I think, are not usually put in positions where they are the ones being observed. They're the observers and they're the decision makers. And my experience is that they tend not to like being studied at all, particularly when they're not told about it. So I suspect we'll get some saucy letters from judges once the results are published, but we haven't had too much pushback so far.
Okay, interesting. Let's see, one question that we had was, is there any training that's being done for judges in terms, I know like we talk a lot about implicit bias training for judges, in terms of dealing with litigants in front of them, but is there other training on this particular issue?
Not that I'm aware of. Okay. And I suspect there won't be, in large part because judges, particularly at state courts, tend to be, so when we're talking about the Supreme Court, I mean, sometimes they weren't even judges before they became judges. Sometimes they weren't even lawyers, right? They were law professors like me, and that makes me a little uncomfortable, but they're doing a great job. So, but state court trial judges tend to come from the pool of attorneys in the community. And so they came out of the environment that is creating this problem. And so I think judges are saying, yeah, we're willing, racism exists. We're willing to talk about implicit bias training, or, sexism and gender bias exists. So we're willing to be trained here. But I think enough judges won't even recognize this or accept this as a problem. And you've got to, I mean, they get to make the decisions on what they're trained in because they're judges and they're their own bosses essentially. And so I think it's unlikely that we'll be to a point anytime soon where we're training judges on the effects of bias in this case and how hard it is to recuse. Although I will note, I presented an early stage of this paper a few years ago at Notre Dame Law School. And if memory serves, Amy Coney Barrett came in for a little bit and listened. So yeah, I don't know. I doubt she remembers it. And if she remembers it, I don't imagine it's impacting her decisions all too much. But
Well, I do want to talk about the recusal issues with the hearings, but we do have another question. If you could do the study again, what would you change, if anything, and why?
That's a great question. So I think I'm going to sort of preface this with so studies like this, anytime you're studying people, particularly when you're doing something to people, and we're doing something to people here, these judges were sent a treatment, and we observed their behavior without their permission. So we had to get approval from what's called an institutional review board. And they're basically a board that reviews the ethical implications of the study to make sure that people like me aren't, in the name of science, abusing vulnerable populations or unaware populations. And so there were a few things that we wanted to do. It ended up, we probably wouldn't have been able to do them anyway for logistical reasons, but we would have liked to have told the attorneys. So instead of relying on sort of this possibility that letters increase disclosure and then looking at whether disclosure impacted case outcomes in those cases, we wanted to just randomize disclosure. So an additional treatment arm could have been, in addition to telling the judge, we're also going to send a letter to all the attorneys or all the parties involved in the case. And that way we can know for sure that all of the participants know, and then test whether knowledge or disclosure is going to increase the rate at which attorneys ask judges to recuse. And we didn't have ethical problems with that, but the IRB had concerns. Basically, the IRB said, you are not allowed to tell anybody but the judge about this. And I think the concern was anytime once you get it outside of the judge, it's outside of the judge's control. So that information could get to anyone, it could get to the newspaper, and that would be out of our control, and that could be damaging to the judge's political career. It could get to other judges. And so I think if we could do this again, that's something that I would like to do. But I don't think we will be able to do it again. And if we did, we wouldn't get permission to do that. There are other things we considered, like, well, what if we did tell the newspapers? But we as me and my co-authors decided we don't want to do that, because we're concerned with the ethical implications of sort of, a fire spread of information and being out of control there. We assumed that the attorneys would be responsible with the information, and thought they deserved to know. Frankly, we felt that there was a good justification for providing them with the information, but the IRB disagreed. I'd also, if we did it again, it'd be nice to have samples in more states than just Wisconsin and Texas. Not all states can do it. Obviously, not all states elect judges. We couldn't do it in those states, and we had to have data to do this. And in the end, there were only about 6 states where it was even feasible. But the more states, the better. The more generalizable the information, the stronger the statistical power, the more interesting differences we might be able to observe. Yeah, that's a great question.
Yeah, it was. So let's talk about the potential Justice Barrett. I mean, the recusal issues there have seemed to center on past positions she's taken on critical cases that are coming up, right? And on potential bias that might come into play if there's any election related
Right.
litigation, right? So, I mean, how does that type of bias differ in your mind from campaign finance type bias?
I would say that the sort of the former category, which is the fact that she has personal preferences, and that as a previous judge and a legal scholar has written on sort of her legal philosophy and the way she would approach cases, is not really at all like the sort of bias that happens when an attorney makes a donation to a judge. I don't think that warrants recusal in really any world. Every judge is going to come in with personal preferences. Every judge, particularly if they were a judge previously, will have, any judge on the Supreme Court will have had a legal career previously, and you could probably make some conclusions on what they're likely to rule on based off of that previous legal career. And I don't think in the law, or even if the law said it, just as a practical matter, that would be appropriate to ask judges to recuse from those sorts of cases. But the latter category, which is, is she potentially going to be biased in favor of cases that either deal directly with President Trump or that deal with policies that President Trump is pushing through, is a lot closer to this idea that there might be some quid pro quo going on, where if an attorney donates to a judge, that judge is going to, quote unquote, pay back the attorney, either purposefully or not purposefully, is going to be biased in favor of that individual. Is a lot like this idea that maybe they'll be in favor of Trump. I think it depends on the situation. So from what I've seen, the two main areas that the Democrats have been concerned with in the hearings are abortion and the
Affordable Care Act.
the Obamacare. And I think those are sort of two different issues. So, and there's a third one, which is if there are problems with the election, or if President Trump or Joe Biden push in the courts for a review of some election result, if that makes it to the Supreme Court, she should recuse there. And I would say in the case of abortion, so abortion is just going back to this idea that she has personal policy preferences. She's a conservative judge. I mean, there's no one's arguing against that. And she is personally opposed to abortion, even if she won't say that during the hearings. We know that from her writings. And she has a legal philosophy that would lend itself to outcomes that would be against, that would be pro-life, not pro-choice. I don't think that warrants recusal, unless there's something we don't know. I don't think that warrants recusal. I don't think recusal is appropriate for the healthcare Obamacare issue either. Every Supreme Court justice is appointed by a president, and every president has policies that make it to the Supreme Court. The election concern is something that I think warrants recusal. And it warrants recusal not because she was appointed by a president. It's because she was appointed by a president during the election. And the election has started. I mean, people are voting in large part because the COVID election is such a weird election where people are voting early. Voting during an election where President Trump has already, maybe not even insinuated, said that he is going to pursue action in the courts. And so the potential for quid pro quo, and even more important than that, the perception that there could be quid pro quo in that case, is, in my argument, totally sufficient for her to recuse. Now, with the Supreme Court recusal, they have even more discretion than other judges. So this will be determination ultimately up to her. And I don't know what she wouldn't even be willing to say whether she'd recuse, and that's probably appropriate because she doesn't have all the information at this point. But I would say I can't think of any circumstances where a case related to the election comes up to the Supreme Court and she doesn't need to recuse. Mostly because the damage that could do to the legitimacy or how people perceive the Supreme Court is so high that, as we talked about earlier, recusal statutes don't just require or ask the judges to recuse when they're biased. They ask the judges to recuse when there's a perception of bias, and there's no way around the fact that there will be a perception of bias particularly if it's a close case, if she's casting a vote that puts Trump back in office. I think that will do maybe irreparable harm to the American perception of the Supreme Court. And so I would say that absolutely warrants recusal. So I think that answers the question.
It does. And I tend to agree with you on all points. It's an interesting situation though, because we have this sort of indirect finance issue, right? That seems to be coming up again and again in the Democrat questions, like these interests are financing President Trump, who then picked you, and that's an indirect bias, right? And I think that's different.
I mean, I'm inclined to say that's just part of the wash. I mean, trust me, if the roles were reversed and we had a Democratic controlled Senate and a Democratic president, and we had a fairly progressive justice who by all measures is qualified and smart,
Right.
but is really progressive, you would hear the exact same arguments, I think, from the other side. So who's funding this? And, you know, are you going to overturn whatever case we're concerned about? And why won't you tell us what you're going to decide? And the other side would just say, it doesn't matter. She's qualified and she's brilliant. So why do you care so much about policy? There's so much political blunder with the just blustering with this, and this is true all the time. But so much of what they're saying is, in my opinion, hypocritical, because I know that they would be making the opposite arguments if it was on the other side. So that's frustrating for me. But a lot of the question, particularly the recusal question, I think is so unique to the current circumstances that it's not only appropriate, but it's sort of mandatory to ask her. So if any of you have, it's over now. The hearings are over, right? This is
one more minute.
Okay. Yeah. The hearings are over at this point, right? This is the last day.
Yeah, this was the last day for the committee.
I would have, and I didn't watch today. She kept saying, I can't talk on cases that haven't come before me. The question I wanted to ask her is, did Trump ask you how you would rule on an abortion case? You're not willing to tell us that, but did Trump ask you, and did you tell Trump or President Trump? And either she'd be dishonest about it, or I suspect she'd say yes, in which case then we could, I think, have more of a reason to demand to hear her position. Because if she's sharing that position with the president, then her reasons for not sharing it with the Senate, I think, lose a lot of their merit. So yeah, we'll see. I mean, I fully suspect that she will be our next Supreme Court justice. I think she'll do a great job. Doesn't line up with my personal policy preferences, but I think she'll do a good job. But if the time comes that she's reviewing a case, I will be signing whatever petition or speaking on whatever radio show will let me about the need for her to recuse. I think that'll be a really important issue.
Well, thank you so much for presenting and for highlighting these issues. I think it's really front of mind in so many ways right now. And I think I agree with you on all the recusal. Most of all, I love the courts. I love the judicial branch. And so I think right now more than ever, it's important that we keep that legitimacy intact as much as possible.
I will say, sometimes I'm accused of being mean to judges. I love courts and judges too. Okay, so let's just make that clear on the record. I love judges. I find them fascinating institutionally and individually. So I hope no one feels bad.
The desire to make the institution better just shows that you do love them. So
it all comes from the heart. Yeah, exactly. My heart's on this side. Yeah.
Well,
okay. Well, I will say, if anybody wants to reach out, all my contact information is online. You can go to the BYU Law website. Happy to talk about this. I'm happy to talk about research, JD, PhD programs, JD programs in general, whatever you want. Please reach out. I'm happy to talk.
Okay, thank you so much. And we'll see you all next week with Marina Lowe. So thank you guys. Take care.